Hi everyone and welcome. My name is Ellen McNally. I am the Marketing Director here at MDeverywhere. I would like to thank all of you for joining us today. Our topic, it's a relevant one, HIPAA privacy, security, enforcement, and breach notification rules changes. Jennifer Kirschenbaum with Kirschenbaum & Kirschenbaum Law Firm out of Garden City, New York is our presenter today. Jennifer manages the firm's healthcare department and specializes in representing practitioners in licensure matters, regulatory compliance, audit defense, transactional matters, litigation, and collections. Thank you for joining us today, Jennifer.
Thank you, Ellen. I'm so happy to be here and for the opportunity that MD is giving me to further get the word out about these many burdensome HIPAA changes that have come down that are now going to be requiring action by all practitioners prior to September of this year. Now, I just want to make sure that we can utilize the presentation properly.
Okay, and what I do want to point out just on the housekeeping side, if anyone does have any questions during the presentation, simply type them into the questions chat window. As we're going along, we will not have time on this session to actually answer the questions live. However, we will follow up to all of them as follow-up to the webinar. HIPAA, I do want to also point out, everyone will receive a recorded copy of the webinar so that you will have that for your reference afterwards. So the HIPAA rule changes, as Jennifer indicated, it's a big topic, so let's get started. Jennifer?
Thank you, Ellen. Okay. So today's agenda is very specific. We are going to go over the changes to privacy, security rule, and breach notification rule. And the changes are many, as I indicated already. Some of them are very nuanced, some of them are very specific. Every single practitioner who qualifies as a covered entity, which we'll go over, will be impacted. And will be impacted significantly because this area of law, which I know we may not think of it as law because it happens day to day, patient coming in, it seems very kind of real life-esque to us that we want to make sure that our information is protected. But this is an area of law that has to be taken very seriously and is going to be taken a lot more seriously by practitioners in the coming years, and I'm going to explain why. And it's because of the second element here, the new enforcement efforts. This has not been an area historically where there has been a lot of enforcement. It has been mainly by patient complaints that we've seen issues with HIPAA, and that is going to change to a degree, and we're going to review that. So also a simple disclaimer, we do not have enough time this afternoon to provide an in-depth analysis of everything, and I also certainly do not have time to give an overview of these rules because they are extensive, and we usually do a whole semester of a law school class on these laws, which we do not have time for in 1 hour. So what I'm going to do is to devote our time towards addressing the various changes that are going to be impacting medical practices. So I will go over a few definitions so that way we're all on the same page, and then we'll get into the changes. Hopefully everyone on this call is familiar with the privacy rule, which requires that certain patient information, which we'll get into which information that is, be maintained in a certain way. The rule also prohibits and authorizes only certain disclosures. The rule requires all covered entities, I referenced this name already, to maintain certain technical, administrative, and operational safeguards to protect unauthorized disclosures. Now, many practices that I work with feel that it suffices that they have a piece of paper that tells patients that their information will be protected. That is not enough. You are technically not in compliance with the law if you are just falling back on a policy. The policy has to be very specific. You are required to have a policy. You also have to have additional safeguards built into your practice to make sure that patient information is not being disclosed. Now, an area of concern had come up a couple of years ago. You may recall the discussion on red flags. Now, this was a requirement that came down that for a very short period of time actually applied to medical practices, and then an exception was carved out. The red flags rule was in addition to the privacy rule and attempted to protect against information theft, and would have required all medical practices to have a policy in place to protect against identity theft and in my mind, really clearly, insurance fraud. It required you to have safeguards such as maintaining photos of patients on file and confirming when you call a patient that you have the patient on the phone and you're not giving out information to someone other than the patient. This is no longer required for medical practices, but I highlight it because when you're dealing with privacy, you should understand that there are all different areas of potential exposure. And we're going to get into compliance to a degree when we go through the changes, and we will. Right, sorry, I know my screen is not changing yet because we're not done yet. We will go through the different changes, and I want to highlight the red flag. Sorry about that. Just because it is something that I think all practices should consider, that when you're dealing with privacy, there are avenues other than just what we're going to be covering today that you should be sure to highlight and make sure you're covering. A very simple example is computer screens in the practice, of course, should not be facing outwards towards the waiting room, and when patients walk around into the actual physical practice, they should not be able to see the screens while they're doing so. So that's a simple little trick. Oh, okay. Sorry about that. Okay. Now, we covered the privacy rule just generally. The security rule is similar, drafted similarly, and what it is it addresses electronic protected health information, which we all have, and it discusses how that information is required to be maintained physically, and also technical safeguards that are required. So hopefully we all have been taking care of that and implementing into our practice safety when we're using electronic information, and that would include when you're using email. You should make sure that certainly all of your emails are encrypted. You want to make sure computers are password protected. You are required to have a security policy if you do anything with a computer. So if you put information just on a laptop, but you're not even doing electronic claim submissions, you are required to have a security policy right now, which many practices do not, but you are required to have. It hasn't been such an issue before because there hasn't been much enforcement, but that, as we'll discuss, is going to change. Just so we're on the same page, again, I want to make sure that we cover what is actually a use and disclosure. Okay? Now, an authorized use or disclosure, as you'll see here, I have it listed, is when a covered entity is disclosing any protected health information to the individual, and you are allowed to use, obviously, their information and give it to them. You're allowed to use their information for treatment, payment, or health care operations, and pursuant to a valid authorization. So if anyone is unfortunately involved in a medical malpractice action, you've received a proper HIPAA authorization form. Hopefully it's a proper HIPAA authorization form. You are allowed to disclose, of course, under that type of situation as well. There are certain required disclosures. Those are under public health needs or emergent situations, but all of these should be reviewed. Okay? Now, this is a new change, our first change. It's the definition of healthcare operations. And you'll see that this is going to actually be a very big change, in my opinion, because what they're doing is they're defining healthcare operations to to include quality assessment and improvement activities. Now, quality assessment and improvement activities will include population-based activities such as case management and care coordination. There is a big change here, and the change that I see that is going to impact many is now that healthcare operations is going to be included as an authorized disclosure. The many requests that some of you may be receiving for documentation in order to check quality assurance or care coordination, things like that, those are getting a lot more prevalent, and that's why this was actually included as a change. And what that's going to mean is that now you're going to be required to provide that documentation, whereas certain instances, private payers, including GHI, United, some of the big players nationally, they were asking for elective production. You actually were not required to provide medical records in response. And in fact, our law firm is very successful mitigating those requests under HIPAA by notifying the carriers that they were not authorized to be requesting documentation in this manner for this purpose, because as we discussed in the previous slide, you were previously only allowed to disclose for treatment and payment and limited healthcare operations. It did not include this element of the definition, so you were able to kind of get away on a technicality and not have to produce, which no one wants to have to produce, especially if you are a smaller practice under 5 doctors. You may not have the staff to sit around and produce hundreds of records just on a whim of an insurance company to try to look at quality data. So this is going to be a big change, and it might make it more burdensome for certain practices. Privacy definitions. Now, who is a covered entity? Covered entity is a health plan, a clearinghouse, a provider who's transmitting health information in electronic form. So it's basically almost anyone and everyone that is dealing with electronic information. Now, I have clients who are still utilizing paper claims. Of course, that is probably going to stop, and I won't be able to say that in a few years. But as I said before, if they're utilizing any electronic means at all, just to be safe, they should be abiding by the HIPAA rules to make sure that they are fully in compliance. So what is protected? And what's protected is going to be individually identifiable health information, okay? And that basically qualifies as anything that you could use to identify an individual. It can be a picture, it could be a social security number, it could be a license number, really anything you can think of that would point you to a certain person would be considered individual identifiable health information. And as we progress with our technology, technology is always actually ahead of the government. As the government catches up, they may also look to include IP addresses, possibly patient portal identifications, if any of you are going towards patient portals at this point in time. That may be used as individually identifiable information. Telephone number potentially. So this is really everything. I mean, it kind of kitchen sinks it for you that everything is protected. So where are we not allowed to utilize this individually identifiable health information? You're not allowed to use it anywhere. You can't use it in electronic media. You're not allowed to transmit it improperly. Only the proper uses and disclosures under the law. So here is another change to protected health information. There was a carve-out included in the new rule that certain information in an education record or an employment record will no longer constitute protected health information. And I want to be really clear on this. This is a very narrow exception. This is not meant to be a broad exclusion. So if you have information that identifies a person that is health related and it is in an education record, depending on physically where it is in that folder, if it's a subpart that is actually a medical record, you are going to still be required to maintain that information under the HIPAA rules. However, if you are talking about a patient's name that is in a different part of the education record that relates obviously to education, then that information would no longer be protected. So if you in your practice happen to receive anything that relates to this, what I would say is if you have it in the patient file, I would still keep it protected. If likewise, if you're sending an information over to a school, let's say for vaccinations, this is going to be their requirement to be maintained, assuming that you've, of course, received proper authorization for the disclosure. Employment records, same thing. Each of us has employees, and for all of our doctor's offices out there, if you are treating an employee as a patient, which I strongly recommend you do not do for conflict of interest purposes and whatnot, I would recommend that you do not do what some of my practices have done in the past, which is stick the medical information into their employee record. They should be treated like any other patient. Have a full medical record kept separate if you are going to do it, but again, I don't advise it. Now, additional change, a person who's been deceased for more than 50 years, their information will no longer fall under protected health information purposes. Now, there is an exception I could see to this that has not come down and was not actually in the regulations that were published. The government publishes very lengthy regulations that explain the intent and public policy behind any new law, and that's in the Federal Register, which is where attorneys and interested parties can go to understand what's been implemented and why. What they did not clarify is if there would be any exceptions to this 50 years rule, but what I believe is that there would be certain instances where it would potentially be confidential, possibly for a public figure, let's say. So I'm not sure if Elvis's medical records have been released or will be, but I would imagine that there would be an interest in keeping those private. Okay, new deceased individual rule. This is a change. If a patient is deceased, you are now authorized to disclose, if you would like, this is in your discretion, to a family member or other individual involved in the patient's care or involved in payment of care to you. So that's a great little exception there. And the disclosure has to be relevant to the person's involvement so long as you're not going against the deceased's intentions. So it would have to be really someone that you know or has been indicated in the record of next of kin or the emergency contact, and you really should be keeping any kind of disclosure narrowly tailored to the person's involvement. So if it's a payment-related conversation, there's no need to disclose certain diagnoses that you may have rendered unless they're relevant and you believe that it is an appropriate disclosure. You do have latitude here. So an example that was actually given in the register is you can disclose circumstances that led to a passing, and you can disclose billing information to a family member assisting in wrapping up an estate. So if they're trying to work out what's due and owing in order to settle the affairs of the family and your bill is unpaid, then you can certainly pass that over. You should not share information about past unrelated medical problems. This is not the time for idle chit-chat, so please use your professional discretion. And I will say that an easy way to have a complaint made about you to the Office for Civil Rights, which is the HIPAA police for all intents and purposes, is to be cavalier in your communications about protected health information. And this is an example of that, of where that could possibly happen. So they're allowing you latitude, but please use your discretion wisely. The minimum necessary standard is not new, okay, for a covered entity. It is not. Just to review, minimum necessary, which is already a standard as a rule, requires that when you're making a disclosure, you utilize reasonable efforts to limit the disclosure of the protected health information to the minimum necessary required to accomplish the intended purpose of the disclosure. So we're not sending in volumes, we're sending in the minimum amount that we have to get the job done on what the request is. So what is new here? What's new is that the minimum necessary standard is now applying to business associates. And we'll get to business associates, but MDeverywhere is a business associate to its clients. All billing companies are. Okay, and we're going to go through more entities that are. So now MDeveryware, which I'm sure they've been doing in the past because I know that they do their best to be compliant, which is why they have these calls and try to educate the public and themselves, are now required to use and disclose protected health information in the minimum necessary possible. Okay? So this is going to be a new standard for everyone's billing company. And you're going to want to make sure that they're following this because, as we're going to get to a little bit later, if they are not complying, you yourself may have exposure. So you do want to make sure that you're working with a compliant company like MDeveryware, and you are doing your due diligence when you sign on with an entity to make sure that they are aware of these requirements. Because I can tell you that having had my exposure to billing companies, the majority of them, when you say, do you comply with minimum necessary, they're going to turn around and say, what? Huh? What is that? They're not even going to know what the standard is. So certainly you want to make sure they're speaking the same language as you are and that they're doing their best to comply, because their exposure will very soon potentially be your exposure. And we're getting to that right now. Your business associate rule is now changing, okay? The old rule, which is stated here, was a person who performs functions or activities on behalf of or certain services for a covered entity that involve the use or disclosure of PHI. This new rule, which is different, encompasses some elements of the old definition into the first, but it's anyone who's creating, receiving, maintaining, or transmitting protected health information for claims processing or administration, data analysis, processing or administration, utilization review, quality assurance, patient safety, billing again, benefit management, practice management, and repricing. That's our first one. Now, that does not mean the biller who works in your office. This would be, that person is an employee, assuming they're an employee or an independent contractor. They would not be a separate business associate. They would be your employee. And you should have other policies and procedures that would cover them, but it would not have to be a business associate agreement, which we'll get to. Business associate also a person who provides management, administration, accreditation, or financial services. So for anyone out there who is accredited, you are required to have a business associate agreement with the accrediting agency if they are to come in and look at anything. Health information organization. This is new. This is anyone who's involved with routine access to your data, okay? And this is a big deal because it's not really clear exactly who's going to qualify, and it's somewhat of an all-encompassing term. The Federal Register does attempt to provide guidance as to whether an entity would fall within the definition of a health information organization, and they do provide guidance on routine access, which means where an entity is more than a mere conduit to your practice. So to determine whether a service provider of yours is a health information organization, you will have to look at all the facts, including how the entity needs access to protected health information to perform its job for you. So if the entity you're looking at is, let's say, an internet service provider, just providing data transmission services, it is likely a conduit and would most likely not qualify as acting as a business associate. The Federal Register does provide more information on conduit, and it says a conduit transports information but does not access it other than on a random or infrequent basis as necessary to perform the service as required by law. So your ISP provider would likely qualify. Your marketer, who is doing also your ISP services potentially, or vice versa, and also has access to certain information or to your server for certain reasons would likely, in my opinion, not qualify. And you would be required to have a business associate agreement with that individual to ensure that you are operating compliantly. There is further clarification. An on-site contractor, someone who's working at your location who has more than incidental access. So this would be someone who's separate apart from your practice and is either a member of the workforce, is not going to be a business associate for the purposes of HIPAA rules. An on-site researcher also, it will depend on how much access they have and what their relationship is to your practice, whether or not they will be included as a business associate. Your bank is not a business associate unless they're assisting you with some sort of qualitative analysis and they have access to your protected health information in your system. Then I wouldn't worry about it, okay? All right, business associate uses and disclosures. A business associate can use and disclose protected health information only as permitted under the business associate contract that you have with them. Now, you are required to have a contract with every third party that has access to your protected health information at the practice. So I would recommend adopting a form business associate agreement that's easily changeable. This is the type of document that you can do that. The majority of the terms, I would say 99% of the terms of the contract will not have to be changed from relationship to relationship. And once you have this on file, you can just make sure that you have a new relationship of the practice, execute this document, and then you'll be good to go. A business associate is required to disclose protected health information when it's required by the secretary. This is the secretary of HHS, to the covered entity and individuals as necessary whenever it would be required by the practice. So they do have to comply and help you if you're working with a billing company, let's say, and you're under investigation or subpoena or audit. They are required to give you whatever information they may have on your end regarding your claims transmissions. So business associate contracts, we've already kind of touched on this, but it is now critical that you pay attention to this requirement because your contracts are going to save you, frankly, if you are, for any reason, reported to the Office for Civil Rights, the HIPAA police, or if there's an investigation launched, your contracts and your policies and procedures will save you. Another thing that is relevant, worth noting, is that your contracts are allowed to include additional assurances of compliance, which you could ask and should ask your business associates, your billing company, your marketer, whoever has access. You should be asking them for additional assurances that they're complying. You also are allowed to put into these contracts risk-shifting provisions, such as an indemnification clause. And that's something that you can look into. Business associate subcontract. Now, it's very straightforward. A business associate is permitted to subcontract, and that's pretty much it. But the subcontractor is going to have to appropriately safeguard the information. And the arrangement between the business associate and the subcontractor may not permit the subcontractor to use or disclose protected health information in any manner that the business associate is not entitled to. So this is also another inquiry that you may want to ask your billing company, your marketer. Are you using anyone else? Do you keep everything in-house? Is it physically in-house, or do you use other avenues? And are you making sure that everything else is secure? And the reason why you want to do this, which we'll get to, is that you're going to have potential liability for the acts of your business associates. Okay, so this is going to be something that is a very big change. The final rule has removed a key exception to the HIPAA rule, which is that covered entities, medical practices, previously were not liable for the acts of business associates. And when I say medical practices, by the way, I'm also including hospitals and any healthcare provider was not previously liable for the acts of their business associate agent, okay? Now, agent is an important key word here, which we'll get to. So previously not liable for acts of agents. In the case where the agent was a business associate and where the relevant contract requirements had been met. They also would have been excluded if the covered entity didn't know of the pattern or practice where the business associate was in violation of any contract. So you had a couple of ways out here. You also would not have been held liable if you did not fail to act, meaning if you did not find out there was a violation and you didn't do anything. So if you just had basically no knowledge, no reason to think that they did anything wrong, you did not have liability for what the business associate was doing if they were an agent. Now, if they're an agent now, you will have potential liability, and we'll get to a big part of this talk is there are huge ramifications should you have liability now, which did not exist before. And when I say now, again, I'm sorry, I do mean September of 2013. That is when everything's going to be coming into effect. So agency is a big deal here because this is not just going to be, if you have a contract with a billing company, let's use MDE for example, okay? If you have a contract with a billing company, you are going to be responsible, which is I know how MDeverywhere works, for the preparation for all of your claims. And you're responsible, obviously, for the medical documentation. That's your purview. You're responsible for the coding. All of that is under your house. Once you turn it over to your billing company, they are responsible, presumably, only for the transmission and for collecting your account receivables. And they will have their own process for doing that. And what is very clear from the Federal Register is that there is no agency relationship if you do not have any control over how the business associate is doing their work. If you know you're contracting with MDeverywhere to handle all of your billing, and you're responsible for your sphere, which is creating the data, seeing the patient, documenting everything, and you are then transmitting to MDeverywhere, where they are doing the claim submission and collecting all of your money and giving it back to you, that's all things that you're not doing at your practice. All the things you're doing at your practice is not what they're responsible for. You have no control over what they're doing because you're just sending your claims over and they're being processed or not, however MDE decides to handle it. And that's it. So there's no agency there. Where there would be agency is if your billing company allowed you to come in and snoop around and give specific direction. So let's give an example of a clear business associate agent. Let's say you have hired a company to come in and help de-identify your patient information for quality assurance purposes. So that way you can look through and tabulate your data. If this individual is coming in as a separate company and they're working out of your office and you are giving specific instruction on how you want things done, we are creating an agency relationship. So what I'm trying to show you, without getting too legal on you, is that this is not going to be a bright line rule. It's going to be more so a fact-based determination. And if you are not sure, then ask. There are no silly questions, and you do want to make sure your relationships are defined properly. So you could err on the side of caution and make sure that you protect yourself through a contract, or you could also ask for additional information from the business associate you're looking to engage. But just be aware that if you do hire that person to do the de-identifying, and let's say you're hiring even a college kid who's a whiz at computers, and you just happen to be treating a celebrity, and they just happen to take that information out of your practice, and they happen to post it on the internet, you will be held liable, and you will potentially be responsible for massive fines if that is reported and it is shown that you had a level of control over this individual to create an agency relationship. So that's very important. Okay, this is a new change. Patients are required electronic protected health information upon request. Now, this was never in here before. If a patient wanted a record, you would just provide them with their paper record. and you would be able to charge them for the amount of money the paper costs you. In New York State, that's 75 cents a page. I'm not sure what it is in other states that I have to check. But now you are required to provide them with electronic protected health information, and you are required to do that within 30 days, which also before there was not a time requirement. So if the patient asks you for information, please make sure you give it to them. Fees. This is also new. This is a huge area of potential exposure, and I will be happy to explain why. I have actually been involved in multiple, I'm going to say several, but multiple investigations of the Office for Civil Rights over fees. We all know patients do not want to be charged for anything, let alone their own medical record. And that's the nature of the complaints that have been received and my involvement with OCR. There have been complaints by patients who were annoyed that they had been charged for their medical records. One complaint that was received was over $4.19 between the cost of an actual X-ray and the charge that was passed through to the patient. It was $61 approximately for the X-ray that the doctor had to pay for the copy, charged the patient $65 rounded up, and patient complained to OCR. And what resulted was, of course, legal expense, responding to the government agency, because the worst thing you can do for your practice is speak with any government agency or investigator. You will be doing yourself a disservice, I promise. So you have to deal with a legal expense to clean this mess up, and then you have to deal with, of course, getting into compliance. So preventative compliance, I will tell you this, is always cheaper. To make sure you're operating properly and have the right policies and procedures in place will save you 10, 20, 30 times on the back end should you be looked at and require defense. Okay, so you are now entitled to charge a reasonable cost-based fee for record production, including the time of technical staff to create and copy electronic files, compiling, extracting, scanning, and burning protected health information. This could also include time spent preparing an explanation or summary of the protected health information. But you are not allowed to charge a retrieval fee for the cost of finding records. The big issue with the changes to the fee is that the direction given by the government is just not clear. We know that we can charge something for the records, but the explanation and the law itself is really not specific enough to know exactly what you can charge for and what you can't charge for. What I would recommend, because I don't like to see any of my clients held hostage by their patients or employees, is that you do not provide these records for free for fear of not being charged, or of being reported for charging. I would recommend that you make an itemized list, similar to the legal bills I'm sure you receive, to the patient for any records that they are requesting, and explain clearly what they are being charged for. I think that that's the cleanest way to do it. If a complaint is made, usually it is because the patient does not understand the charges, or if it's made because of excessive fees or they don't want to pay anything. You can't please everyone, and sometimes patients are just going to be litigious or report you. So at least at that point you would have a clear written record, what was done, why it was done, and that's how I would recommend you. Changes to the breach notification rule. This is also going to be a major change. And I see we don't have a lot of time left, so I'm just going to hurry up. The harm standard, this is a big deal. Okay? The harm standard is no longer what we're utilizing. We are now changing to if there is a risk assessment that there's a low probability that protected health information has been compromised, then and there's no significant harm to the individual, you are no longer required to report the breach. This is significant because they're not basing whether or not a patient was harmed as the standard. So where you had accidentally mailed a Social Security number, whether or not the patient suffered a loss was the standard. Now it's either that there's a probability the information has been compromised. So it's a very different standard. So if the patient wasn't harmed before, just because the Social Security number went out, it meant that you didn't have to report. Now, even if the patient has no harm, but there was information compromised, you are required to report. So in that same situation, Social Security number goes out in the mail by accident on the front of the envelope, you are now required to report. Okay? There's factors that are to be considered. They are detailed. You can see them actually here. And I'm going to actually move on because there's still a lot of things we have to get to. So it's nature and extent, and whether or not the unauthorized person would disclose, or if there's any other kind of protection. So in the Social Security example, you would have to clearly report. If you do find that your office is potentially at risk or has done something where you're not sure if it was a breach or not, you must contact your healthcare attorney. And I say healthcare attorney, stressing that. You cannot call a lay practitioner or your real estate attorney or trust and estates attorney. They're not going to know what the heck you're talking about. You must speak with a specialist in this area, and you're going to have to evaluate whether or not it's time to self-report. Self-reporting is a terrible, terrible thing. It brings scrutiny down on your practice. You would like to avoid it whenever possible. However, if you are found out prior to self-reporting, that can be worse. So this is a very serious situation that you want to make sure that you are addressing properly. This is a new provision. There were a lot of comments on this. Also on the next one, which is that you are now going to be required to obtain an authorization for any disclosure for marketing, okay, except if it's a face-to-face encounter with a patient or if it's a promotional gift. So this is new. If the marketing involves being paid for that marketing, the authorization has to state that you're going to be paid for the marketing, okay? So closing. So fundraising is the next one, and this is also new. There were a lot of comments on this. It was eventually adopted to include that the covered entity may use protect health information for raising funds for its own benefit without an authorization, so long as your privacy practices explain this might happen and the patient is able to opt out. So this is required to be in your privacy policy, and that's a change. That's new. Okay. Sale of protected health information, also a simple change. For certain purposes, you're allowed to sell protected health information now. Again, consult with your attorney before doing so, because there are ramifications to this. New requirement for privacy practices. You are required to contain a statement that indicates if you are using or disclosing psychotherapy notes, or if that applies to anyone. Uses and disclosures for protected health information for marketing purposes also, we went over quickly, and disclosures that constitute a sale of protected health information require authorization. So there are a number of different changes that are actually going to impact what you have to have on file and what you have to give to your patients. Also, again, fundraising has to be included. Notice requirement is the same. If you have a change to your privacy policy, which you are required to have before September, you have to notify your patients of same, and you have to have it available, and you should be posting it in your location. Genetic information we're not going to get into. This is a requirement for health plans. This is a significant part of the changes to the rule, but again, it is for the health plans to comply with. Disclosures of immunization. There's no longer a need for written authorizations anymore. You can get an oral authorization, which will save a lot of practices hassle. Okay, so similar to the continuing legal education I have to do, I decided to put a code in for this presentation. For those of you still listening, you get the benefit of it. We are offering a discount code for 10% off of all compliance documents, which is valid until the end of the month, or the Friday before the end of the month, with MDE 101. I'll give the code again later. We do offer all privacy policies and security policies and additional information that we're covering today, which I'll show you where you can get that. But we're offering 10% off for all participants of the webinar. And again, we want to thank MDE for allowing us to get the word out. Okay, enforcement provisions. This is a very big deal. This is a huge change. This is changing the entire face of HIPAA, how privacy is going to be seen. It's now going to be seen more of a legal, litigious situation, I believe, than just kind of a hassle the practices had to put up with. there is just a basic policy shift in the Office for Civil Rights, the HIPAA police. They've been very amicable in the past, and they really had a focus on compliance, wanted to make sure patients were happy, the doctors were working helpfully, and that's going to really start changing come September. Well, it's already changing now, but it's really going to start changing in September because that's the deadline. But I've already seen a change in investigations that I'm working on. The manner has changed, the discussion, the discourse has all modified towards compliance and really putting pressure on the practitioners to make sure that they are doing everything properly. So if the complaint indicates initially that there is a violation due to willful neglect, which means the conscious, intentional failure or reckless indifference to the obligation to comply with an administrative simplification provision, which, by the way, is anything under HIPAA, then there will be a fine imposed, essentially. So we're going to go through that. Now, this is for violations after February 19th, 2009. They will impose a civil monetary penalty. That's what they're saying, but I don't actually think it's true. I think that they're really going to try to look for new complaints that are coming in after the September date. Okay. Civil monetary penalties, this is what we're going to be looking at now. And I can't stress enough, again, that this is a significant policy change. The verbiage in provisions, which here I highlighted, bolded will. It used to be may. It really is significant changes. The devil's in the details, and I can tell you the details here have changed dramatically, as has the tenor of the relationship between the HIPAA police and medical practices. So civil monetary penalties, here we go. These are the different stages. We're going to go through them quick. The first stage is that if there's a violation in which it was established that the covered entity did not know, and by exercise reasonable diligence would not have known that there was a violation. So you made a mistake, oops, wasn't a big deal. The penalty is going to take into consideration how big the organization is. So if you're a solo practitioner listening and they decide to slap you on the wrist, you are probably going to get a $100 fine. You are not going to get some substantial fine. The $50,000 is so that way maybe a hospital will take notice if, God forbid, they have something like this happen, and it's determined that the first level is what they're responsible for. Second level is civil monetary penalties. This is when we are getting a little bit more serious. This is a violation in which it is established that the violation was due to reasonable cause and not willful neglect. Now, reasonable cause is an act or omission in which a covered entity knew or by exercising reasonable diligence would have known that the act or omission violated an administrative simplification provision. So this has been revised to now include violations due to both circumstances that would make it unreasonable for the covered entity, despite the exercise of ordinary business care and prudence, to comply with the HIPAA requirements, as well as other circumstances where they have knowledge, but they lack the intent or reckless indifference associated with the next category. So this is, you did something wrong, and you shouldn't have, obviously, but it wasn't something that was totally unreasonable. The third category is where we're getting to unreasonable. For a violation in which it is established that the violation was due to willful neglect and was timely corrected. So this is if you had an intentional failure or total reckless indifference. This is something that's really bad. You would now, even if you took time to correct it, be responsible for penalties not less than $10,000 for each violation. So if you have a staff member tweeting about a celebrity in your office, each individual tweet could potentially cost you $10,000. Okay. Fourth, this is for the worst of the worst. This is for a violation in which it was established that there was willful neglect and there was no attempt to correct. So you knew, you could care less, you let it continue to go on, and you now are going to be responsible for not less than $50,000. I know that no one on this call is going to fall into any of the last three categories because you're all taking the time today to learn about the changes. And that shows me that you're trying to make that first step towards compliance, which is knowledge. civil monetary penalties. They removed the affirmative defenses. So really, it's going to be very difficult to deal with this office come September, and that's really the main point, is that you don't want to have to call me to deal with this office in next January. You really want to make sure that you take the time to continue to educate yourself and to get the policies and procedures in your practice, have the training with your staff, and make sure that you know what you're doing. So this is also compliance reviews. These are going to be done, so there's going to be spot checking. It's going to be very, very important that you're actually working to comply before September. This is a new provision. It is very, very important, and it is equally as scary as the fines that I posted in the last few slides. This was not the case before. If you dealt with the Office for Civil Rights, the information was kept confidential. They will now be contacting other agencies and sharing information, such as the Department of Justice. And there's going to be this agency share. So if you are putting in improper claims and you're being looked at for that, then OIG or the Department of Justice might be calling OCR, and you might then get hit with a HIPAA wing as well. Or more likely, it's going to be a patient complaint. They want to see your OCR wants to see your policies and procedures. They start sniffing around. They say, you know what, this doctor, she doesn't know what's going on. She's not doing so well. She's making a lot of mistakes. I bet you that it's prevalent in her, across the board in her practice. It's not just with the HIPAA. It's going to be with billing as well. I bet you we can get some of our taxpayer money back, and we should be looking at the Medicare claims for this practice. And they're going to be able to call OIG or call the Department of Justice. So you do not want to end up on someone's radar because you do not have the proper policies in place. And a patient asks for their records. You don't give it to them within the 30-day deadline, and they report you because you gave it to them on the 35th day without an excuse. You then get a call from OCR. You handle it yourself instead of getting a lawyer involved. You maybe are irritable that day, and then the OCR investigator decides that they're going to elevate and look into your practice further, and you then get referred to another agency. That, my friends, is a nightmare. One that could potentially happen. I am not trying to scare you. I'm just trying to explain to you that this is changing the entire tenor of how HIPAA was looked at and how it should be implemented in your practice. So the modifications that you're going to have to make are not going to be that bad. They're going to be minimal. You're going to need training. Staff needs training, and you'll be ready to go. So compliance dates, September 23rd, 2013. Etch that into your brains. Need to get everything done well before then and get the training out of the way. What's your next step? You have to incorporate the changes into your practice's privacy policies. I don't expect you to do that yourself. You are not going to do it yourself. You are most likely not capable of doing it yourself. You are going to have to get the proper policies. In case you were wondering, the majority of your professional associations do not have the right policies. I have walked into hundreds of clients' offices. They tell me, oh, I got it from the New York State Dental Association. I got it from my specialty, from the Gastro Society, from this, from this, from this. And the policies are wrong. So you want to make sure you have proper policies, that you're addressing your business associate relationships. You should be conducting compliance reviews on a regular basis, which means reviewing general policies and procedures. Also, you want to work with your billing company and make sure that your claims are going out properly. And you want to make sure to prepare in case there's a potential complaint made. So again, here's our discount code, MDE101. It is going to be valid until March 29th. We will be happy to help you with your forms. And these are our compliance documents that we have on our website, which is healthcarepracticecompliance.com. Or you can go to kirschenbaumesq.com is our website. This will take you there, and we would be happy to assist you. We also do a free newsletter twice a week, which you'll all qualify for, and this is also our website, nyhealthcareattorneys.com. We do not have multiple sites. We just have multiple ways to get there. So you can feel free to check out additional educational information on healthcare on our site, and we want to just thank MDeverywhere for allowing us again to get the word out on these many changes. And I want to thank MDeverywhere for being conscious enough to understand that there is a real need for education. So thank you, Ellen.
You are welcome, Jennifer. That is a tremendous amount of information that's just been provided to everyone. Just as a reminder, there were also quite a few questions that were coming in as we were, as Jennifer was doing her presentation. We will follow up with specific answers to all of them following the presentation, so thank you for submitting those. I do want to thank Jennifer for the time she spent putting this information together for us. A little bit about MDeverywhere. I do want to let you know, oh, Jennifer, did I change the screen back?
Yes, this is yours now.
Okay. Oops.
Sorry.
Okay.
Go to the
Yeah, all right. I'm just going to give you a little bit of information then about MDeverywhere. Basically, we are a revenue cycle information company. We provide cloud-based technology. We provide the billing services. We do include a business service agreement with our clients. We want to make sure we're HIPAA compliant and our clients are HIPAA compliant. We streamline charge capture billing processes. We work well with just about any specialty, any size organization, from solo practices all the way up to large group practices, IPAs, faculty practice groups, hospital organizations. We have a patient portal to encourage patients to go online, make payments, take electronic payments. We also offer a full suite of enrollment and credentialing services. We're NCQA certified. If you have any questions about MDeverywhere, email or phone me. I'll be happy to provide information to you. I do want to let you know that that concludes our presentation for today. I want to thank Jennifer again for a very detailed presentation, providing expertise on these changes. A link to today's recorded presentation will be sent via email to everyone. And that's it. We're going to close out with that today, and I do want to thank you all for your time. Have a great day.